Good morning and good afternoon, everyone. It's Allie here over at the Core Group. We thank you for joining us. A few housekeeping items really quickly is if you can just write any questions you have during the presentation into your question box, and I will make sure to get them over to Mike at the end. We're so grateful to have Mike Kenny from Nationwide with us today to talk about our Medicaid SPIA. He's actually been with Nationwide since 2002, so he is a wealth of information, and we're just so grateful. Mike, I'm going to pass it over to you if you want to talk a little bit more about yourself and what brought you here today.
All right. Well, thank you, Allie, and thank you for inviting me to present this information about Medicaid annuities and how that process works. As she mentioned, I've been with Nationwide back since 2002, been in the financial services industry since 1992, and most of my career as an advisor and with Nationwide, my focus has been on retirement income distribution planning, but along the way, some other topics of interest as part of the Nationwide Retirement Institute, of which I am a member, include things like Social Security strategies, healthcare costs in retirement, long-term care costs, identifying those and helping people prepare for those costs in retirement. We've also got some new programs such as how HSA accounts can integrate into a retirement plan, tax-efficient retirement income, focus on women in retirement. And we bring these tools and education programs, CE presentations to the field really as part of our thought leadership and the overall solutions that Nationwide Financial likes to bring to you as advisors and your clients. So just quickly here, we're not going to get into any tax or legal advice. Gotta let the lawyers have their say here. So annuities are obviously guaranteed by the claims paying ability of the insurance company, but this presentation is really educational in nature and to help you have a better understanding of how a Medicaid annuity works and some of the various rules and legislation that surrounds that. So, deciding how to pay for health care and long-term care and retirement are really difficult choices that the clients and their families have to make. And as an advisor, you may not necessarily see yourself as someone that can help in these decisions, but clients are often going to turn to you for guidance and advice. And when it comes to long-term care, these decisions carry more weight and really have greater consequences. So if you can offer a solution that helps a married couple or their family be able to afford long-term care while protecting financial resources and assets, you can really enhance how your clients value the guidance that you provide, and you become a source of reassurance for your clients during those trying times. But note that the actions your clients take in this context must be based on advice that they receive from their attorney. So when you're working with a Medicaid situation, it's always advised to have an elder care attorney that's really the quarterback of the situation and the strategy, and they're calling the shots as far as how the annuity is structured, how much money is going into it, who's the owner, who's the annuitant, who's the payee, etc. So all of those things really should be driven by an attorney, but it's really valuable to have a basis of knowledge so you can have meaningful conversations not only with your client but with the elder care attorney as well. So today, during the presentation, we're going to talk about a variety of topics. We're going to talk about the eligibility that asset and income limits will drive, how you can eliminate excess assets. We'll talk about some of the laws that surround Medicaid and the use of annuities. It really dates back to the Deficit Reduction Act of 2005. It was signed into law in 2006 by President Bush. We're going to talk about how you can maintain and support the spouse's lifestyle if one spouse becomes institutionalized and the other remains in the community or family home. We'll look at a couple of case studies, and then we'll talk about some gift penalties and the calculations that go into that if somebody gifts money away prior to trying to apply for Medicaid. So let's first talk about the asset and income limits for qualifying for Medicaid. exempt items are typically called non-countable assets. There's a variety of those types of things like household furnishings, property used in a business, clothing, jewelry. Those types of things are personal property that are exempt. Prepaid funeral expenses can be of any value as long as they're irrevocable. There is a $1,500. If not, there's a $1,500 limit. So in other words, if you buy a plot but it's not an irrevocable expense, then that may not count up to more than $1,500. Cash value and life policies with death benefits that do not exceed $1,500. Which is a relatively low amount. There's no limit on ownership of term life insurance policies, but whole life policies have a very small allowable cash value. An automobile is also exempt up to about $4,500 in value. And income for a Medicaid recipient is limited to a monthly personal needs allowance. It's usually $50 to $90, depending on the state that the individual's in. So here's some of the asset and income exemption limits for married couples. So you can have a family home valued up to $585,000. In some states, it's higher than that. California, New York, and Hawaii, for example, even Alaska, I believe, are a little bit higher. A car can be an unlimited value for a spouse. Again, burial plot or prepaid funeral expenses, the personal property. There's some limits on that. It's not. It typically doesn't come into play. Financial assets. So if you've got a married couple, the spouse may retain, in most states, the lesser of $126,420, or half the amount of their overall assets. So if somebody starts with $80,000 in assets, they may have to spend down to $40,000. If somebody had $1 million, they would have to get down to that $126,420. There's some income limits as well, and those income limits are minimum maintenance monthly needs allowance, or MMNA. The maximum amount is $31,650. So if you've got an institutionalized spouse and they're generating income from Social Security, pensions, other sources, some of that may be able to go to the spouse to get them to that minimum monthly needs allowance. And then how can we eliminate assets? So if you've got an individual that's going into a skilled nursing facility, they can pay off any outstanding bills, credit card, those types of things. They can pay that off. Their personal property, again, is exempt, prepaid funeral, and then they can also purchase an immediate annuity. With a spouse, there are some additional things they can do. They can utilize all of these methods to reduce assets, but they can also pay off a mortgage. They could do home improvements. Maybe they want to put in a wheelchair ramp or something like that, so when the spouse comes home to visit, they're easily able to move about the home. They can purchase an automobile, and again, they can also purchase an immediate annuity. So all of this stems back from what I mentioned earlier, which is the Deficit Reduction Act of 2005. That's when we shifted from a 3-year look back to a 5-year look back. But it also brought into play the ability to use an immediate annuity as long as it was set up properly and is actuarially sound. In other words, what that means is that by the time an individual reaches their life expectancy, we have to have paid back the full amount of premium or principal that they put into the annuity. It has to be irrevocable and non-assignable. In other words, J.G. Wentworth cannot buy your annuity. It has to be a term certain, no longer than the life expectancy of the annuitant. So there's tables that elder care attorneys will use. Some use the Centers for Medicare and Medicaid tables. Others will use a Social Security life expectancy table. But they're fairly consistent. Again, this is something you're going to defer to the elder care attorney as far as what that term certain ultimately will be. It can have no cash value or liquidity feature, so people cannot access those funds in a lump sum in order, to basically kill the annuity at any point in time. It also has to be equal payments. There used to be some annuities out there that had balloon payments. So in other words, they might pay $1,000 a year for 10 years, and then at the end they'll pay $50,000. Those types of annuities would not be able to be used in this type of situation. In most states, the state Medicaid program could be the Department of Health and Human Services, or there may be a special insurance department that handles Medicaid, but they're typically going to be named the beneficiary after the spouse. If it's an individual, they're going to be named the primary beneficiary, and to the extent of any services that they pay for. So, for example, if somebody had an annuity, they passed away, it had a cash value at that point of $100,000, and Medicaid had paid $50,000 for services for that individual, they would take their 50, and then the remaining 50 could go to contingent beneficiaries. So one of the main reasons that the Deficit Reduction Act addressed this situation was obviously to increase the look-back period, but also wanted to eliminate impoverishment for spouses. So oftentimes what would happen is a couple would have one spouse goes into a skilled nursing facility, and the couple has to spend and use up all of their assets to pay for the nursing home before they could qualify for Medicaid. And then what happens is once they run out of those funds, not only is the government paying for the care of the individual that's in the nursing home, but now you have an impoverished spouse that may need additional assistance from the government as well. So that was one of the main reasons that this was created, and also provides that minimum monthly income allowance to the spouse. If their income is less than that, then it's an income first rule, which means that they're going to be able to get to this $31.60 per month prior to paying any of the income to the nursing home itself. If their income is above that, then any income that the spouse is receiving, whether that's from an annuity or from working or a pension, whatever it might be, that's ignored for Medicaid purposes. So that does not impact their ability to qualify for Medicaid. So I mentioned before, it's really important that you're working with an elder care attorney. It's really the key to successful Medicaid planning. So the decision to use a SPIA should be based on a legal recommendation with very specific contract needs determined by the elder care attorney. And an attorney will work with an advisor to help a client purchase a contract. Again, they're going to identify virtually everything that has to do with that contract. So from the perspective of an advisor, what you're really doing in this situation is, holding the hand of your client and taking an order versus getting involved in the overall details of the contract itself. So let's look at a case study. So this is a hypothetical situation. So here we've got John, who's 83, and Barbara's 81. They have assets. They have a home, a car. They have some personal property, and about $250,000 in cash. John has Social Security of $1,250 a month, and Barbara is at $500 a month. And this is one of the important things to consider in this situation is more often than not, the cost for a Medicaid bed is significantly lower than it is to pay for that privately. So if you do nothing else but get somebody qualified for Medicaid, you're going to be able to extend the life of their assets because you're going to be paying significantly less for their long-term care than you would in a private pay situation. So the first step in this is to determine how much Barbara is able to retain. So they had $250,000. So remember, we've got the 126 and change rule, or half of their assets. In this case, they had 250. So we're going to go down to one half of the assets. So 125 is what Barbara's allowed to retain. Then with the remainder, they're going to purchase an annuity that meets the Deficit Reduction Act requirements. So again, non-assignable, non-transferable, actuarially sound, and a term certain that's not exceeding their life expectancy. So in this case, an annuity could be purchased for a term that does not exceed her life expectancy, which is a little more than 8 years. And in this case, Barbara chooses a 5-year term certain. You can go shorter than life expectancy, but you can't go longer. And then the purchase amount, we put that $125,000 of excess assets into the immediate annuity. It'll generate a little over $2,100 a month for 5 years, a total payout of $127,834. So as long as this payout is more than the amount that they put into the contract, then it's going to meet that actuarially sound component that we're looking for. So here we have the minimum monthly maintenance allowance that Barbara's allowed to keep. So that number is $3,160.50. Barbara's getting $500 in Social Security, and she'll be getting $2,130 from the immediate annuity. So she's $529 short from that minimum monthly maintenance amount that she's allowed to keep. So then we look at John's income. So he has $1,250 in Social Security. We've got the $529 from Barbara. John's allowed to keep $50 in this hypothetical for his personal needs, which means their copay to the nursing home is $670.07. Now, when we think back to what the costs were for Medicaid in that situation, they had a $10,000 per month expenditure if they did not qualify for Medicaid. By going through this process, they've reduced that amount down to $670. So you can immediately see what the benefit of this could be for individual or couple. So John's able to immediately qualify for Medicaid. They bring those costs down. Barbara's able to keep that $125,000. So some of the disadvantages would be that if Barbara passes away before the end of that 5-year period, the state's going to recover their cost of care. When and how they do that depends on the state. In some cases, they'll take a lump sum death benefit immediately. Others will take the continued stream of income until it's paid off. So that varies from place to place. But in general, they're going to get theirs first before any other beneficiaries can get a benefit or death benefit from that contract. So as a result of that, it's entirely possible in that scenario that the kids, grandkids, and other heirs might not get a lot from that annuity if Barbara passes away. But then again, the cost of doing nothing, that $125,000 that Barbara was looking for or was able to keep, would have been depleted in less than 13 months. So clearly a potential advantage by that money flowing back to Barbara. Again, she's allowed to have unlimited income, so none of that money is going to be touched by Medicaid in that scenario. Now, it doesn't work quite as well for an individual as it does for a couple, but there's still some advantages. So this next case study has Sarah, who's age 84. She's entering a nursing home. She's not expected to live very long, less than a year. Her Social Security life expectancy is 84 months. So what we can do is set up an immediate annuity that's 84 months or shorter. She's got assets of $145,000. She's got Social Security income of $1,050. And again, we're going to use those same costs for a Medicaid bed and private pay, $6,000 versus $10,000. So what Sarah can do is purchase an immediate annuity that meets the Deficit Reduction Act requirements. So she purchased that with $143,000, and that's going to generate a little under $1,800 a month for 84 months for a total payout of $151,000. Her copay for care is a little under $2,800, so that's going to be her $1,050 from Social Security, plus the annuity income, less the $50 monthly allowance. And then Medicaid would come in and pick up the remainder, the $3,200, to cover the full $6,000 cost. So here, again, she immediately gets Medicaid eligibility. She's reducing her monthly cost from $10,000 down to a little under $2,800. And again, if she dies before the annuity terminates, some or all of the money could go to her heirs, depending on how much Medicaid paid. So they could, they may receive very little if she passes away longer into the 84 months. But if she passes away fairly early, the heirs are going to receive a pretty significant amount. And the cost recovery from the annuity could diminish or potentially even eliminate what the heirs get. But again, the cost of doing nothing, the $143,000 in excess assets that she has would be depleted in 15 months at that cost of $10,000 a month. So we're extending the life of those assets by a significant amount of time. So one thing to keep in mind when it comes to Medicaid planning, if people gift away money, don't make donations, that type of thing, within that 5-year period, there's going to be a potential gift penalty that will basically create an elimination period before Medicaid eligibility will come into play. So think of any transfer that's out of the estate, except to a spouse, could and will cause a penalty. So any transfer or gift made during the look-back period creates that penalty. And basically what they do is they take a look at the average costs for a private pay bed in the zip code or community that someone lives in, and then they're going to divide that amount into the amount of the gift to come up with the elimination period. The maximum is going to be 60 months. Clearly, it's it's a 5-year look back, so anything beyond that would not make any sense. So here we're looking at an example. So somebody made a gift of $200,000. The average cost of care in that county of residence is $6,000. So the penalty period for that is going to be the time before Medicaid will come in and start paying. And then what they'll do is, again, they'll take that full amount of the gift, they'll divide it by the average cost of care. So in this particular case, you'd have a 33-month and 10-day elimination or penalty period before Medicaid would come in and start paying. So as I mentioned, these situations can be fairly complicated. Whenever you're dealing with one of these situations, it's always a good idea to involve an elder care attorney. I wouldn't recommend that any advisor try to do this on their own or any client try to do this on their own. It's always a good idea to involve the elder care attorney for your safety, protection, as well as the client's. And really the best reason to use this type of strategy is when you've got a couple and you want to protect the spouse from impoverishment. And so it's important, again, to know a little bit about the asset and income limits, and they vary state by state to a certain extent, so you may want to take a look at those for your particular state. The spend down requirements, what are the rules for a spouse, what are the state recovery provisions, and again, an elder care attorney should be very well versed in these types of situations and know exactly what the state laws are. So, and then again, immediate annuities. When I think of this, it's kind of a last minute type of an approach. It's not something that you're doing on a long range planning type situations, because there's trusts and other things that you could do earlier in life before somebody actually needs long-term care. But when you're up against the wall, this is really the only solution typically that makes sense and enables people to immediately qualify for Medicaid, lower those costs, and protect some of their assets. So that's really my presentation. I want to make sure that we have an opportunity to answer any and all questions that people have. And we've got a fair amount of time here. So I'm going to look through these questions.
It looks mostly like everyone's just wondering if we can maybe have a copy of the presentation that we can share. And I'll put a link, if you're able to give that to me, I'll put a link up with the on our website with the link that shows the recording as well. If that's cool with you, Mike.
Absolutely. I'll send that over to you as soon as we're finished here.
I'm going to look through. I don't know if I see any others. Oh, there is one up here. The penalty period for an ineligible transfer does not begin until the actual Medicaid application, right?
That's correct. Well,
for the example, since 2005, it does not begin at the time of gift, correct? That was the question.
Yeah, and some of that can vary as far as the calculation state by state, but in general, yes, that would be the case. But the time of the gift is somewhat important as well.
Perfect. Let's see. Then another question is, do you do joint work?
I'm sorry, say that again.
You said, do you do joint work? Maybe I'm not sure what that question is. Roberto, can you maybe clarify what you're asking? And then I'll
do a lot of conference calls with attorneys, advisors, and clients. I don't know if that's perhaps what they're referring to.
The next question says, what is the shortest SPIA term that you can use?
Well, currently nationwide shortest is 3 years. There are some companies out there that can go a little bit shorter than that. It's a little tricky though, because they're kind of getting around the actuarially sound issue, because they're charging a fee to get into the annuity. And as a result of that, I mean, you could make the argument that it's not really actuarially sound, because you might be paying $5,000 to buy the annuity, and you might only get $2,000 back from the annuity. So it's just something to take a look at. But it is possible to do shorter than that, shorter than 3 years with certain firms, and it can work out to the advantage of an individual, and particularly a couple.
Okay, perfect. I'm seeing another question, I think. Is there any option for a client that attempted to use a non-Medicaid SPIA, for example, beyond the SSA table expectancy?
Read that to me one more time.
Yep. Is there any option for a client that attempted to use a non-Medicaid SPIA, for example, beyond the SSA table expectancy?
Yeah, that can be a little bit tricky. It could preclude them from getting Medicaid because of the fact that they had a non-eligible immediate annuity. If it had a liquidity feature and it was a term certain, they might be able to get out of that contract by basically taking the full amount of the liquidity feature and terminating the contract. But if somebody had like a lifetime annuity or something like that, they would probably have to take a good look at how it's structured. Does it have the contractual language that makes it non-assignable and non-transferable before they would be able to make that determination? So I know the answer is a little bit vague, but it would really depend.
It depends, yeah. Okay. Another question is, if I have a case, can we work on it together, or how can your firm help my clients as I work with many special needs clients and their parents?
Yeah, so I've got this blank slide up here, but our team's number is 877. I'm going to put it in the chat box. 877-245-0763. So we can, answer questions that you or your clients have. We can do conference calls with the elder care attorney. We can prepare illustrations and really help to, guide you through the process from the standpoint of, looking at how much goes into it, what are the life expectancies that we're dealing with. So we can answer a lot of questions. But again, in an ideal situation, you're going to get all of the pertinent information about a contract, ideally in writing from the elder care attorney. But we're definitely here to support.
Sure. Another question popped up. If you put IRA money into a SPIA, do they have to pay taxes upfront, or can they pay the taxes over the life of the SPIA?
Say that one more time.
If you put IRA money into a SPIA, do they have to pay the taxes upfront, or can they pay the taxes over the life of the SPIA?
Yeah, in all cases with immediate annuities for qualified money, you pay the taxes as the money is distributed. So you should never have to pay upfront taxes on a SPIA.
Okay, perfect. Let's see. I think
and
that might be.
I tried to post that number, Allie, but it only went to the organizers and panelists. So I don't know if you want to.
Sure, I will. I'll post it now, and then I'll also include it. I write an email out to all the attendees at the end of each webinar, and I send it out, so it'll have the link. Once you send me the presentation, it'll have that, and then I can put your phone number in there as well.
Perfect.
And then I'll check and make sure we've covered everybody. Send that to everyone. I think we're good. I think we've covered all the questions that I'm seeing come through, and they can always reach out to Alan Bradley or myself over at CORE. So most everybody has our information, but we appreciate you being here today and helping us out with this. Thank you so much, Mike.
No, thank you all. Have a great day.
Everybody have a great one. Bye-bye.